The rule of law, the foundation of a free and fair society where access to justice is available to all. It underpins our constitution and is what drives and unifies our 10,600 employees across 150 countries worldwide at LexisNexis. Enabling the way corporate, legal and government professionals do business, making it possible for them to shape the world we live in for a better future. A leading legal technology organization with more than 85 years' experience in the South African legal landscape, we empower legal practitioners with access to the latest precedents, expert curated content, and solutions to drive the wheels of justice in our country. Using artificial intelligence technologies such as data analytics, natural language processing, and machine learning, we are reshaping the way legal professionals work. We offer governance, risk, and compliance software solutions that assist corporate professionals in proactively identifying and managing areas that are possible for individuals to become the rightful owners of their first homes. Bringing the property ecosystem together by harnessing the power of technology. We get it right so that our customers can get it right. We are advancing the practice of law, the compliance with law, and the upholding of the rule of law. Because at LexisNexis, we are advancing what's possible.
Welcome attendees, panelists to the webinar, and it's an honor to launch Africa's first legal text on eDiscovery, a guide to eDiscovery in South Africa. The role of eDiscovery in the context of South Africa and Africa. We are so excited about this session that will unpack and address the importance of eDiscovery and why we need it. Some basic housekeeping. Please note that we've got the chat bar available for questions from the audience. And please keep the conversations coming and keep it dynamic. And it's going to be an exciting morning. We have limited time with our esteemed guests, so keep them coming. We will be recording the session for those who have to drop off at some point this morning, and it will be made to all our attendees. And this morning, I want to take this moment to welcome our CEO of LexisNexis South Africa, Fedesha, Barrage. Thank you this morning for making the time to join us and to lead us and to introduce our main speaker this morning. But over to you, Fedesha.
Good morning, everybody. Can you see me? Let's just get the tech right first. Mel?
Yes, we can be.
Yes, we can be.
So welcome, everyone, on this rather warm morning in Johannesburg, which we're very pleased about. We've been having a bit of a chill the last couple of days. So I was, for one, very glad to see the sun shining this morning. So welcome, a very warm welcome to everyone. And for those of you that know me, you'll know that, I've spent the majority of my career in the technology fields. And so for me, this is a very exciting day. And so I said to Nelly and Mel that I had to be part of it because, this is a massive change for us in South Africa to be part of the evolution of eDiscovery in South Africa. And I really think that, we talk a lot about the fourth industrial revolution and what that brings with it, this fusion of our digital, physical, and biological worlds. And I see a lot of fear when I talk to customers and partners alike about, what does this mean for me as a company, for me as an individual? And, I really want to stress that although the fourth industrial revolution brings with it a lot of disruption, it also brings with it a lot of opportunity for those who are change able, for those that are willing to go on the journey. It really brings a lot of opportunity, and we've seen this with our customers across the world. And so, it's really exciting to be here today as we really mark a day that is going to change the South African landscape as we take this profession forward with the assistance of technology. And so I urge you to really embrace this change that is happening. And we understand that one of the easiest ways to do that is to make the change more digestible and more understandable. And therefore, we have the most amazing lineup of speakers today. And I really want to thank our speakers. So, our authors, whether it's Terry Harrison and Advocate Hussein, for their commitment, for their bravery in propelling us forward by using technology, in encompassing that into the practice of law. And of course, we have with us today the esteemed and much renowned Judge Jody Kollapen, who, his contributions in terms of our justice landscape in South Africa is well known, but we will spend some time a little bit later introducing him properly. But we really want to thank him for making himself available today to share with us a keynote address that is very exciting. And to my team, the LexisNexis South Africa team, and I really want to thank everybody that has come together to bring this book, this title to bear, in order to really aid us in being able to use technology as an enabler. I think there is a lot of talk in the industry about many things when we think about the legal profession, whether that's billable hours and how we're going to, maximize that. And I think from our perspective, eDiscovery, is really going to have a great effect in terms of reducing the total amount of time that is required to process cases. And as we're able to reduce this burden, might not be the right word, but this task that in the past took a lot of time, it really creates a space for more productivity and for our customers and our partners to really do what they do best. At LexisNexis South Africa, we always say that our vision is really to enhance the potential of the African continent by advancing the rule of law. And that is our North Star. And we really do that by bringing technology to bear. We see technology as an enabler. And we're very proud when we're able to use technology and bring to the forefront technology solutions that helps our customers, our legal professionals, our legal practitioners to focus on what they do best, which is advancing the rule of law. So we're very proud to be able to take away, that background stuff that comes with creating technology solutions as well as, printed solutions, so that we can take away some of their burden and enable you to focus on doing what you do best, which is bringing the magic of the law to bear. And so really, I think, at this point, let's just move towards introducing our keynote speaker for today, who has also written the foreword to the book that we're discussing today, which is Judge Kollapen. And I looked at the bio, and if I had to read the whole bio, it would take us the whole 30 minutes. So I'm going to try and summarize his amazing achievements, but also what is really heartwarming is how passionate he is about the space and how he uses his platform and his ability to understand the law and bring it to bear to really create an environment where advancing the rule of law becomes much easier, not just for South Africa, but for the African continent in its totality. So Judge has been Judge was an acting justice of the Constitutional Court of South Africa from July 2017. And he has served as a judge in the High Court of South Africa in the Gauteng Division in Pretoria since 2011. He's also the chairperson of the South African Law Reform Commission, and prior to his appointment as a judge, he served as the head of the South African Human Rights Commission. Judge Kollapen previously practiced as an attorney and joined the organization Lawyers for Human Rights, where he coordinated the Release of Political Prisoners program, which championed for the rights of political prisoners. And I don't need to tell you that this has been instrumental in moving South Africa forward towards a democracy and bringing us to where we are today. In 1995, he was appointed as the national director. While working as an attorney, he worked on many important cases, such as the Sharpeville 6, the Delmas treason trial. He was also a member of the selection panel that chose the commissioners for the Truth and Reconciliation Commission. As a judge of the High Court, some of Justice Kollapen's celebrated judgments include Henny and the Others versus Minister of Correctional Services, and others in which he granted an urgent interdict, allowing prisoners to use laptops in their cells for study purposes. Judge has also presided in the Limpopo textbooks case, in which he reprimanded the National Education Department and its Limpopo counterpart for its failure to deliver textbooks to schools in the province, and handed down a structural order outlining the textbook deliveries, outlining the need for textbook deliveries and deadlines. Judge previously served as a lecturer at the Center for Human Rights at the University of Pretoria. Moreover, he has served on the board of many civil society organizations, including the Legal Resources Center, the Center for Study of Violence and Reconciliation, IDASA, and the London-based Article 19. For LexisNexis, Judge Kollapen represents a breed of great legal minds, somebody who shares a vision that we share and who sees technology as an enabler to advancing the rule of law. So we thank you, Judge Kollapen, for your lifetime of work and achievements that you have put forward, and for endlessly and really selflessly working to advance the rule of law, and also helping South Africa to get to where we are today. And so we welcome you. Please take the stage, and we're very excited to listen to your keynote address. Judge Kollapen, Judge Jody Kollapen.
Thank you, Fedesha. Thank you for that sort of warm introduction. And as you sort of walk through my career, I suppose I've been very privileged as well to be able to do the work I really love all my life, and I've really enjoyed my entire career without exception. And even today, I enjoy every day of my work because I feel I'm at the cutting edge of doing something that gives me great joy, but also very privileged to be able to make a contribution to this wonderful country in which we live. So thank you for that. And as you introduced the topic, you spoke about the fourth industrial revolution and the uncertainty and sometimes the anxiety that comes with change. You may have also exaggerated somewhat in sort of enhancing my knowledge of technology and the ease with which I use it. I must confess that I'm also relatively new at this game, and I don't blame you for that. It may have been based on perhaps the way I wrote the foreword, but I've really become a fan of it, and I'm on a sharp learning curve. So thank you, firstly, for the invitation to today's launch, and it's certainly an honor for me to be able to say a few words on this occasion. As you point out, just as technology has brought us the possibility of eDiscovery, so too has it brought remarkable changes in our world that even I marvel at from time to time. Just the other day, I happened to be exposed to an app that is able to bring pictures to life. And I was fascinated by this. For some, it might be morbid, but I imagine for others who've never seen a parent except a picture or a grandparent, and this app is able to bring the picture to life. I think it runs for a couple of seconds, a smile on the face, the eyes that come to life. And I've seen people using this app, and it sort of brought great joy into their lives. And so in many respects, you're right that technology has been largely a force for good. But equally, others sort of warn of the downside that comes with it. And I imagine the debate about technology and its benefits and the negatives that go with it will never be fully resolved, because it touches on deep and complex issues really about who we are, what kind of footprint do we want to leave behind, what are the ethical standards that we wish to live by, and how do we make sense of the bewilderment, as it were, of this wonderful world we live in, while retaining some sense of control, some sense of choice in what we do. And I think sometimes the overwhelming nature of just where we find ourselves in can be a bit much for many of us. But the point is, technology is here to stay. We've seen the wonderful benefits that it brings to us, and the challenge is how we manage it. And in many areas, one sees this sort of perpetual conflict. I look at how technology has enabled human contact in ways that we never thought possible. WhatsApp, Facebook, video calling, video conferencing. And I mean, I'm a grandparent, and the joy of being able to talk to your grandchild when you're far away from each other is something that really we thank technology for. But that same technology has brought with it challenges around issues of privacy, around issues of human dignity, around issues in which human conduct perhaps can be said to become conditioned and geared not towards meaningful human relationships, but maybe sometimes towards maintaining a carefully constructed image on social media. And so there are many ethical issues that, even as we welcome and embrace the technology, we are forced to confront and we are forced to debate. In very much a similar way, medical innovations, for example, have brought great advances in improving the quality of life. But it's also taken us into difficult ethical areas. Information and data, for example, about patients and medical staff represent significant financial benefit, and the use of and the access of this data is often contested. At other levels, we are warned that technology may well result in the severing of important bonds that must exist between doctor and patient to enhance, as it were, the quality of the interventions that doctors are able to make. This is not a reason to reject technology, but an incentive to embrace it, but mindful of how we need to negotiate around the consequences that may come with it. And I've watched with great fascination the debates around genetic modification. And while we're still some way from getting there, but the idea around genetic modification is not as simple as some would make it out to be, because some will powerfully and compellingly argue that every child has the right to be genetically unmodified, while others may say that every child has the right to be born free of preventable disease. At the same time, I've also read about what is described as technology's algorithmic instruments, and how increasingly adverts are deliberately directed at people of a particular ideology, a particular political persuasion, or any other leaning or predisposition based on data collected over time with regard to what we view, what sites we visit, etc. And so there seems to be data on each of us that may tell us much more than perhaps we even know about ourselves. And so all of this raises issues that are often complex and challenging, but the bottom line is that technology has brought great benefits, will continue to bring great benefits. It is here to stay. It is likely to play an even greater role in our lives. And we need to find ways to embrace it while maintaining the important discussion on the frameworks that continue to guide and shape our society, our interactions with each other, and perhaps even the way that power is desegregated and power is held accountable. And so in the practice of law, and really most of us today are really involved in the practice of law in the legal industry in some way or the other, technology and digitalization have also brought great benefits, but equally significant challenges. Certainly in our day-to-day work, we see the availability of advanced search engines that can be precision-tuned to target a discrete area of the law, and increasingly may well call into question the functions of law researchers and sometimes even junior lawyers. A company known as McKinsey, and I have no brief for them, they may not necessarily have a great reputation in South Africa, but apparently they've done some research that suggests that some 23% of lawyers' work can be automated as software that can scan legal documents, that can streamline communications, and that can find relevant case law, and perhaps even, who knows, begin to construct a draft judgment based on the facts of a particular case and the case law that's applicable to those facts. But I think it's unlikely that the human lawyer can ever be replaced. I think the emotional intelligence, the sense of judgment, and the ability to engage in teamwork, all that come with human, cannot be replaced by artificial intelligence. But I guess we just have to be mindful that technology makes advances all the time, and we need to keep up with those advances. Certainly in some areas, technology is already predicting how a judge will rule in a given matter, given his or her predispositions, previous rulings, likes or dislikes, memberships of particular social, cultural, religious groups, welfare organizations, etc. And so the technology can be harnessed, as it were, to perhaps even tell us more about ourselves. I would be fascinated, for example, if there was a program that was able to track all of the judgments that I've written. And it may well show up some of my predispositions. It may well show up some of my biases that I may not be consciously aware of. And so it's quite a scary thought, but it's something that I should welcome, because the best judge is not the judge who's free of prejudices and predispositions, but is the judge who's aware of them and consciously asks himself or herself every day the question, why am I deciding this case in a particular way? Is it because I'm convinced by the facts and the law? Or is it because that there's something within my subconscious that may be moving me in a particular direction? And I think that kind of judicial frankness and judicial honesty is increasingly necessary in the society in which we live. And so let me speak a bit about technology in the context of the legal profession and the enormous changes that have come with it, and sometimes the fears that go with it, as Fedesha has spoken to us about. I mean, in the practice of law, the specter of an office from home and contact through technology is becoming increasingly plausible and realistic, and perhaps even necessary in this time of COVID. And what does that mean for lawyer-client relationship? What does it mean for collegiality between lawyers who may be litigating all the time, who may have adversarial relationships when it comes to their professional work, but who often construct great social relationships and great friendships are formed? What does all of this mean? I mean, I've pondered about it with some concern as well. I've worked largely from home in the last year, and while it has certainly brought me closer to my wife, I'm not sure if I always enjoyed as much as I initially did. I find the kind of human interaction that I enjoy from being in a courtroom, the ability to get to know the lawyers who argue cases before me, just not their skills and their expertise, which is often commendable, but really who they are as people. And for me, that's an important part of my work. It's an important part of bringing joy and sort of satisfaction to my daily work. And if that's missing, then I increasingly find there's something lacking in what I do. And there must be an answer to that, but I just raise that as simply pointing out that if this is the future, and it is indeed the future, then we must best prepare for it, and we must adjust to it. And we must find ways of not giving up the things that matter to us as well, and that are important, as it were, in the architecture of our own joy and our own happiness. And so enough about that, because today we're really here to launch a publication that covers an important area in legal practice and in adjudication, and that's discovery, and in particular, eDiscovery. I think it would be simplistic to see this publication just as a tool for better and more effective discovery. And I think it's important to locate it in its proper context, both legally, but also socially and politically, certainly in the context of our country. And in the context of our country, I think few of us, thinking back to 1994, would ever imagine that lawyers and litigation would play such a central role in the trajectory of our society. I mean, there's hardly an issue that is determined in our society without some input from the courts. And some would argue that the courts play too much of a role in the life of our society. But others would argue, well, if you predicate your society on the notion that the Constitution is supreme, then perforce what must follow from that is an important role for courts, and an important role for judges, and an important role for lawyers. And that debate is an important one, in particular at the current time when one sees what is happening around us. But part of that trajectory of the Constitution was what was regarded as the promise of the Constitution. Ours was a negotiated settlement, where the South Africa of the 28th of April was largely no different from the South Africa of the 27th of April, 1994. For millions of people, life was the same. We had a new government, we had a beloved president in President Mandela, and we had the dignity and the self-respect of being able to say we overcame apartheid and we were able to cast our first democratic vote. But the nature of the negotiated settlement meant that the promise of a better life and the promise of a better future would lie largely in the law and in the Constitution. And that promise that would see policy change, that would see legal change, that would result in the delivery, as it were, of this promissory note that was the Constitution, was an important one, because many gave up, as it were, the quest for an armed struggle, the need for a revolution, in the belief that this promise contained in the Constitution would materialize and would change their lives, or if not their lives, the lives of their children. But 26 years later, much of that promise remains unfulfilled. And when one looks at just the area of access to justice as an important vehicle in achieving that promise, then for so many millions of people, access to justice is a promise that rings hollow. Just getting legal representation, getting a case into court, being simply able to vindicate one's rights, to seek to right a wrong, to call into aid the promise of the law, is simply a bridge too far. And so for many of them, the exceptionality of our Constitution is of little comfort, when in truth and reality, they live largely outside of the Constitution, outside of the walls of its promise and outside of the walls of its benefit. And if we are committed, as Fedesha indicated, to the rule of law, and if we are indeed committed to a democratic future, one that is it extends beyond the exceptionality of the paper we produce, then we must be concerned about this trend in our society. And I see it as a judge all the time, that people with resources and people with wealth can come and vindicate their rights. And even if it's a right that is maybe as petty to somebody else as a view of the ocean, but every day people risk losing their homes through foreclosures, which may be validly brought, but they simply don't appear at court. They don't have the legal representation, and they don't have the ability and the means to come to court and to advance a defense in terms of their own house and their own livelihood and their own future. And that's a sad indictment of our society. So this publication around eDiscovery that is committed to greater efficiency and greater access to justice must be located within that broader context as well. And in this regard, the Law Commission, which I chair, will bring out a report quite soon on legal fees as a barrier to access to justice. A number of issues will be dealt with in that report, including interventions that would make litigation more effective, tariff setting, different dispensations for those who litigate in the district and regional courts, perhaps, reducing the cost of litigation through greater use of case management, a greater commitment to pro bono work, community service, and matters like that. And it is in this context as well that eDiscovery becomes significant as well, as part of a move towards the greater use of technology, because it is efficient, because it can be cost effective. And certainly in the area of discovery, as a sitting judge, discovery often results in immeasurable delays in litigation, in getting a matter ready for trial. And there have been important interventions, certainly from the level of the leadership of the judiciary through case management, that I think have been successful in ensuring that unnecessary delays in the litigation process get sorted out, that litigation doesn't sort of lie in the hands of the parties, where the judge is simply an umpire who'd say, well, how's that umpire out or not out? But a judge becomes actively involved in the management of cases. And I enjoyed thoroughly just having parties sitting in your office in a sort of almost less adversarial environment and being able to cut through the issues and get a matter ready, and impressing upon them on the kind of resources it took for a party to even get a case going, and that we all share a common obligation to ensure that that case can work through the court system without undue delays, and the person can have his or her day in court. And so in all of this, discovery becomes important, because discovery, if not dealt with properly, can be costly, can be time consuming, especially in matters involving the complexity of documents. And it's in this area that I do believe eDiscovery makes a significant difference. It works on the back of a technology that can immeasurably assist all of us. And so the book that we are launching today is indeed fascinating, and you may balk at sort of my choice of words. As I indicated, I'm not a fundi in technology, but as I sort of read the book, I looked at the Glossary of Terms, and I was fascinated. And I thought, this is a wonderful glossary of terms, because it almost is like introducing one to a technological drama and a battle of the future. And I just want to give you the names of 4 characters. Well, these are characters, not sort of characters as you and I would, but that I found in the Glossary of Terms. So you'll come across someone known as Blowback. Well, I've sort of taken some judicial license and giving them some sort of qualities. So there's someone called Blowback, who has the ability to convert random droplets of ink into legible characters. And Terry might speak more about this. There's someone called Emoticon, and I think Emoticon is the elder brother of emoji. And Emoticon has the ability to display a range of emotions and act on them simultaneously, something even beyond human. You'll come across someone known as Marginalia, who lives on the edge of the fringes of the internet and cyberspace. I've given these descriptions to these characters as the way I saw them. And then finally, you have someone called Wildcard Operator. And Wildcard Operator really is the go-to icon, someone that can resolve intractable difficulties. So yeah, who would have imagined a book about electronic discovery could produce such memorable characters? But yeah, there you have it. More seriously, however, the book makes the compelling case for electronic discovery. It says it's the right thing to do. It doesn't do so from some moral high ground or some intellectual arrogance, but rather from some really logical and sound arguments. It argues compellingly that documents are increasingly created electronically and not as paper documents. It argues powerfully that the nature of documents and the data that lawyers are required to deal with is increasingly complex and voluminous. And therefore, eDiscovery makes good business sense from a variety of perspectives, from efficacy, from costs, from access. The book also debunks the myth that eDiscovery will benefit larger firms and not really smaller firms. On the contrary, it argues that it's a great leveler because the accessibility to the technology is so easy, it's so cheap, that smaller firms may be able to compete on the same level as larger firms in terms of the ability to use technology to prepare for cases and to in particular prepare for discovery. And so, as it seems to me, the argument may well be that there'll be no paper wars, as litigation can sometimes be, and therefore no paper victories. But the book sort of calls into a slogan, which I found quite interesting: know your data, know your case. And I've sort of, since I've become exposed to this in the short time that I have, had some first-hand experience of this in the High Court, certainly in the last term. At the beginning of this term, I had to do a trial that was set down for 3 weeks, and it involved diesel rebates, a dispute around diesel rebates that SARS had to pay to a particular farming entity. And there were lots of documents in the matter. And normally when you get your trial bundles, I mean, this would have been probably 60 lever arch files. And you can imagine 60 lever arch files being delivered to your office shortly before the start of the trial. It doesn't really put you in the great mood, even though I enjoy my work, but the thought of 60 lever arch files and having to navigate through them in a courtroom. But this didn't happen in this case. My registrar came in and said, "Judge, here's the trial bundle." She gave me an envelope, and in the envelope was a flash disk. And yeah, I mean, there may have been 100 files on a flash disk, double what would have been in my office. But just psychologically, the idea that I could take a flash disk, stick it into my laptop, and voila, the trial bundle was there, was just not something that was efficient, but certainly at another level, just enable all of us in court to be able to function much more effectively and efficiently, and in fact conclude the trial in less than 3 weeks because of the efficiency of something that was as basic as getting the trial bundle put on a flash disk. On the flip side of that, I was in the post-motion court the other day, and there was a battle for two years around discovery in a matrimonial dispute. And I said, this is unacceptable. This matter should be case managed. And I just thought about eDiscovery. It was a dispute about bank statements. So the party was required to produce them, could simply have accessed those statements online, downloaded them, made them available to his attorney, and his attorney could then forward them electronically to the other side. All of this could be been done with no cost. But this dispute dragged on for 2 years. So those are just two examples of where its use has come in remarkably well, and where we're not used, the kind of problems and the prejudice that can redound to litigants. And so as I sort of conclude, I just want to point out that the Rules Board this month published e-rules which provide for the amendment of the Magistrates Court rules as well as the Uniform rules of the High Court. And those e-rules provide for the filing of documents electronically, for e-discovery, for remote and virtual hearings. And I would certainly urge all of you who have an interest in this area to look at those rules and to make comment and suggestions to the Rules Board. And I think sort of finally, what is required of us, and certainly I speak as a judge who may not be as young as I'd like to be, but is a mind shift. Because many have said that they would be unable to make this transition. But if truth be told, it's not really an inability, but rather an unwillingness. Not a deliberate unwillingness, but perhaps an unwillingness rooted in nostalgia and the traditions and the customs of the past. And I'll just reference this by a discussion we had as judges when we were talking about replacing the paper library in our court with an electronic library. And a colleague then said, you know, I really love to get up from my desk when I'm writing a judgment, walk across my chambers to my bookshelf, pull out a law report, blow the dust off it, feel and caress the pages. And then I feel, right, this is what my work is about. I can relate to that 100%. But the reality is that our transformation as judges and as human beings is about change. And that is a ritual. It's not indispensable to our work. And we need to find ways of moving beyond that. And those things, important as they are, cannot be cast in stone. And just as last year brought enormous changes to all our lives, even the most reluctant amongst us was able to work on case lines and on teams. And certainly in our division, we were able to do most of our work remotely. As I indicated earlier, it came with its disadvantages. But with case lines and with Microsoft Teams, we were able to conduct litigation almost as effectively as we would do so in open court. So there's a powerful example of how technology has ensured that the judicial system, an important cog in our democratic dispensation, did not come to a standstill. And so finally, I'd like to commend the authors, Terry Harrison and Ismail Hussain, who really bravely ventured into an area of law and technology that appeared out of bounds for many of us. They've, through this publication, made it understandable, made it accessible, and assisted us really in taking a significant step to the future, but you'll probably hear more about that shortly. And so finally, I would sort of, as a careful and keen judge, reserve judgment in important matters such as this. But today, I would say I'm confident enough to give an extempore judgment and really commend the book to all who are committed to enhancing the efficacy of the litigation process and of contributing thereby to a greater access to justice. I don't wear a watch, so I may have gone over my time, but really thank you once again for the opportunity to say a few words, and congratulations to LexisNexis and all of those who've worked on the book and who've made its launch today possible. Thank you.
Thank you, Judge Kollapen. It really has been an amazing keynote speaker. You delivered it so calmly, so positively, and we could really take in every word that you shared with us today. It really has been our pleasure, and we humbly say thank you. And we just want to take a few things. I just want to take a few things that Judge mentioned to us in a little bit of a summary as I was listening to how both from Fedesha and from Judge Kollapen, how technology is changing the way we do things. And I love what Judge was saying and reminding us of the 27th of April of 1994. We sometimes tend to forget that wonderful, remarkable day and what it brought to us, a promise of a better future, larger in the law and constitution, how important that is to us, and that we should not track away from it, but stay committed to the rule of law. Also, the trend of just the way we are conducting ourselves from our constitution, where we used to live it since 1994. We have veered off a little bit, and Judge is reminding us to come back to it and to see how important, and as he so rightfully said, the cog in the wheel is around law and how technology has helped the law to continue when the pandemic hit us last year, and that technology enabled that, and how exciting this eDiscovery book is today. That also helps us to offer and give access and make it affordable to people to fight for what is right. As he gave us an example that a lot of people don't show up because they don't have access to legal assistance. But certainly the book is going to help us, and it's a new change for all of us, trajectorying us into, as Judge has said, transformational, and it's about change. And he said it's a ritual. And I really love what Judge was sharing with us. And I love the characters that Judge brought to life as well. How exciting that it's not boring. It gives us something from a drama perspective, because we all love drama and we all love stories. So thank you to the authors, and thank you once again, Judge. And with no further ado, I want to say and welcome our panelists, because we are a little bit into our time. So thank you, Judge. We enjoyed that. So we gave you all the time. And I want to welcome our panelists this morning and introduce to you Terry, who is an author and an independent consultant. Terry is the only independent e-discovery consultant in South Africa, very exciting, and he advises law firms, corporations, and service providers. He is a regular speaker and writes an award-winning blog on the subject. Previously, Terry spent 25 years as a litigation fee earner in law firms in the UK before moving into litigation technology, where he was MD of UK litigation technology provider in London for 15 years. He was one of the founders of eDiscovery in the UK, organizing and speaking at the first ever UK eDiscovery seminar in 2003. In 2014, Terry moved into Cape Town with his South African wife, intending to retire. Terry has single-handedly pressurized the Department of Justice to incorporate eDiscovery into the Uniform Rules of Civil Procedure, and the Rules Board have now established a task force to deal with this, a move supported by the South African Law Reform Commission, which mentions Terry in its discussion paper on legal fees. Welcome, Terry. I'm now just going to quickly also introduce my colleague, Samantha Reddy, and she's been with LexisNexis for 12 years. Areas of speciality are family law, criminal law, civil procedure, and constitutional law. Her focus is to help them become better practitioners, judicial officers, and prosecutors, as well as building and maintaining a strong, effective relationships with authors. Sam has a P.Prog from the University of KwaZulu-Natal and is a qualified attorney and my esteemed colleague. So welcome, Sam. So with no further ado, I want to jump in, Terry. And we all know that you've been doing this far longer than most of us and believe that you are the best placed individual to really simplify this topic for us. So briefly, can you tell us what is eDiscovery? Why has it become such a vital part of the legal and corporate world? Over to you, Terry.
Right, thank you very much, Mel. First of all, you will have noticed that Ishmael isn't with us because he's in court. Thank you very much, Ishmael, for making sure that I have to answer all the questions. And just before I start, I have to say something about the Glossary of Terms that Judge Kollapen very kindly referred to. I'm responsible for writing that. I have to say, it took me a long time. That was 2 weeks hard work. But when I sent the draft glossary to Ishmael, he said to me, Terry, I would buy the book just for the glossary alone. Well, I can tell you that I would buy the book just for Judge Kollapen's foreword alone, especially after hearing his insightful and I thought very, very caring comments this morning. It was amazing. Anyway, you've asked me about eDiscovery and why is it so important? So the thing is that you have either a few minutes answer to that or a 3.5 hour one. So for all those listening, please settle in your chairs for the long version. I'm only joking. The official definition of eDiscovery is that it is the collection, production, and review of documents that are stored in electronic format. And by the way, for documents, you can now also include communications. Well, in essence, it is the complete end-to-end process of how we deal with electronic documents and communications for discovery and beyond this discovery onto trial. Over the last 20 years, the business world has changed. In particular, it's changed the way that it communicates and creates documents. Statistics tell us that more than 97% of all business documents are now created electronically. So it is the evolution of how business is done now that makes eDiscovery essential. And it's important to understand that eDiscovery does not change the basic principles of discovery in any way, shape, or form. Standard discovery is to make a reasonable search for documents that are or have been in your possession or control. And if you find documents that support you or are adverse, then you must disclose those to the other side. Everybody knows that. Well, there is nothing in eDiscovery that changes that principle at all. It is actually an evolution, not a revolution. So it's not the rules or the principles that have changed. It is the methods of communication and document creation. And so we need eDiscovery to handle that properly. Furthermore, and Judge Kollapen mentioned this at one point, the volumes of electronic documents are so high and still rising that without technology, you simply would not be able to handle them. A comparatively small case could easily have 500,000 electronic documents. And what eDiscovery technology will do is to quickly find the documents within that large collection, which may be relevant and that you as a lawyer would really need to see, whilst at the same time setting aside those that are unlikely to be relevant. And I mentioned communications as well as documents earlier. And whilst we don't have time to go into detail today, you have to consider nowadays social media. You have to consider communications on cell phones. And I've written a lot about both of these topics in the book. And as Judge Kollapen said, emojis and emoticons, I need to tell you, are potentially discoverable. There have been decided cases in other parts of the world confirming those facts. So it is the proliferation of electronic documents that makes eDiscovery so vital, indeed imperative, for the legal and corporate world. And unless those documents are handled properly, well, bluntly, you're asking for serious trouble. So that, Mel, is the few minutes answer.
Thank you, Terry. Just another one. We have spoken at length about the importance of eDiscovery and the role it plays in both the legal and corporate world. And I know you're very passionate about it. Can you give us some insights on the risks and dangers faced by the legal and corporate profession if they choose to ignore eDiscovery?
Yes, thank you, Mel. The most obvious risk and danger is that documents will be missed. And if they're not found and seen, they won't be discovered. And how would you know that a missed document may even be the one which would have won or lost the case? Now, I know, as I've been involved in such matters here in South Africa, that many times emails, for example, are printed either by the law firm themselves or by the corporate client who hands the documents over to his external lawyer for preparation of the case. Guys, you should never print emails and rely on them. If you print, you might miss attachments. You will miss BCCs or blind carbon copies, so that you would not know that the BCC recipient ever saw that email. And that in itself might be crucial in your case. And you will miss those emails that have been deleted. Now, if you remember the phrase in the definition of standard discovery, are or have been in your possession or control, well, that would obviously apply to emails and other documents that have been deleted. Now, if we weren't able to do something about that, it would be a nonsense, because you'd simply find an email or a document that you don't like or that isn't going to help your case, you just delete it and that's the end of it. Well, it isn't with eDiscovery, because part of the eDiscovery process refers to how electronic documents are collected. And if they are collected properly, in many cases, probably forensically, then deleted emails and documents will be found. Here's one which some people, some lawyers in particular, particularly in South Africa, raise their eyebrows and question, but electronic documents are more evidentially reliable than paper ones. Partly because of everything that I've just said, but mostly because in eDiscovery, when we process electronic documents, we capture the all-important metadata of each document. Metadata comprises the properties of a document. So, for example, an email would have metadata which would include from, to, whether there's a CC or a BCC, the date and time, the subject. In short, metadata tells you who knew what, when. And as an investigating lawyer in any kind of a case, it's exactly what you want. You know, I was involved in a matter once in the UK in which there are a large number of minutes of meetings. And they were given in their printed paper format. And one set said that a particular person was not present at the meeting, when it was actually contended that he certainly was. And the minutes were in the form of a printed Word document. So we actually found the original electronic versions, and in particular of this particular set of minutes. And the metadata on that electronic version showed us that someone had altered the minutes by inserting the word not before the document was printed. But it was the printed version that had been given as far as the case was concerned. So you tell me, which version was more evidentially correct, the electronic one or the printed one? Pretty obvious, isn't it? Another important risk and danger is in respect of costs. People say, yeah, but eDiscovery technology is expensive, and it's just ridiculous, can't afford that. Statistics tell us that the proper use of eDiscovery will reduce the cost of a case by at least 30%. And the danger of ignoring that is that even less litigation cases will be brought. Comment made by Judge Kollapen, we're very concerned about access to justice. And as things stand in South Africa, if you, in Gauteng, for example, if you remove the cases that involve the government, and then remove the cases that are RAF, the Road Accident Fund cases, then there is little left already. So access to justice is obviously already an issue, and it's impacting on jobs for attorneys and advocates too. And we heard Judge Kollapen, and in the SA Law Reform discussion paper 150 about legal fees that he alluded to, he emphasizes the point that using eDiscovery will reduce the costs of litigation. And so in summary on that aspect of the whole aspect of eDiscovery and risks, it avoids the risk of missing documents, it maintains evidential reliability, and it reduces the overall costs. Now, of course, all of that is important to attorneys, but it's even more important to corporate clients, as they are the ones with most to lose or gain by a litigation case, and they're the ones who are paying the bills. I've said for many, many years that the establishment and development of eDiscovery technology has not been driven by lawyers, nor has it been driven by scientists in Silicon Valley. It's been driven by what I call globalcorporation.com, who has continually and is still saying, we will not pay excessive fees for our litigation cases. You must use technology, and technology must improve to reduce the costs. So therefore, my message here in South Africa right now is to both law firms and to their corporate clients: ignore eDiscovery at your peril. There we go, Melanie.
Thank you, Terry. Thank you so much. I'm now going to move to Sam. Congratulations on putting this title together and your author selection. Can you bring a more LexisNexis perspective to the discussion? Why was it important for you that Africa's first legal text on eDiscovery is published by us? You're on mute, Sam.
Thanks, Mel. It is a very, very exciting time. One of my regrets, though, is that we aren't able to have this book launch in person. I'm sure it would have been a very fun event. When I first started researching this topic, I was surprised at how little information there was in South Africa, which just goes to show that this title is going to provide much needed guidance for our market. At LexisNexis South Africa, we are always striving to ensure that our customers are kept updated with the latest in legislation, case law, and market trends. So it made absolute sense for us to get this content out to our customers as soon as possible. We also endeavored to get source the best authors around, authors who are leaders in their field, well-respected, well-known, and very relevant. I feel very privileged to have been able to work with such professional and dedicated authors. Ismail and Terry poured their heart and soul into this book and dedicated so much time to make sure we could publish timelessly. Both are very skilled at what they do, but they're also very cognizant of the fact that this is new content. So they've written in a way that's very easy to understand and follow. The Glossary of Terms that Judge spoke about earlier is just one of those practical additions to assist one in navigating their way through all those strange terms and acronyms. In fact, I think it was when I first reviewed the chapter that Ismail sent to me, and I replied to him to say I was struggling to follow all this gobbledygook, and he was quite impressed with my legal or my technical terminology. And I think it's at that stage he asked Terry to get ready with that glossary. So basically, lawyers can't afford to be tech averse. In fact, I think it may be viewed as unethical if they do not utilize tech in order to best serve their clients as well as justice. I think eDiscovery should be viewed as part of a lawyer's ethical duty to provide competent representation. As market leaders at LexisNexis, we are continually evolving and looking for new ways to best serve our customers. Being the first to market with this title is just the beginning of this journey. We are committed to providing information and guidance required for our customers to confidently move towards a tech-enabled practice. So, yeah.
Thank you. Thank you, Sam. And I know when I joined last year, LexisNexis, this was one of the things that was on top of your list. It was, Mel, I'm going to do eDiscovery, and LexisNexis has got the platform to launch this. So we are so excited, and congratulations again. Terry, back to you. I want to get into the practices of the book, as I know this is what our audience is here for. Terry, your co-author, Advocate Hussein, as you mentioned him earlier, he couldn't join us today, wrote chapter 7 on eDiscovery and court case management, where he's shared practical advice to lawyers. Can you take us through some key points as to how using eDiscovery can reduce search and case preparation time? We also know that everyone is under the belt at the moment, so please touch on how eDiscovery can reduce costs, which you already did, but I think the chapter 7 discovery would be amazing this morning. Thank you, Terry.
Pleasure. First of all, I agree. Ishmael's chapter on eDiscovery and case management is indeed a really excellent one, with lots and lots of practical advice. The first being that the attorney needs to take steps at the earliest opportunity when considering electronic documents in a matter. And Ishmael rightly mentions that even before there is a case to deal with, a good lawyer engages with his clients about what we would call litigation readiness. And this involves how the client stores, retains, and preserves their electronic data. In other words, information governance. The retention and preservation of documents is very important, as are the methods of recovering those documents. And Ishmael, this is a direct quote from his chapter, says, smart lawyers who learn the rules and use technology correctly can rest assured they will be prepared for litigation in the 21st century. The converse, of course, is also true. Think of a situation where law firm A is pitching for a case against for a potential corporate client against law firm B. And in the bid document, law firm A says, as head of litigation and senior partner, I will look at every single document in this case personally so that I can give you the best advice and nothing will be missed. Law firm B says, we will use technology to ensure that we do not look at every single document personally, and we will use the various techniques in the technology to find relevant documents quickly, which we will look at personally. So which is the corporate client going to choose? Because one will charge his high hourly rate for looking at absolutely every document there is, including irrelevant ones like, are we going to meet for coffee? What are we having for dinner tonight? Whilst the other will work smart and save his hourly rate just for those docs which require his personal skills, expertise, and attention. And as I said, Ishmael mentions working at the earliest opportunity in cases. And in another part of the book, by the way, I write about what we call early case assessment, which is using eDiscovery technology to learn about your case as quickly as possible, rather than just blindly starting to read boxes of paper as we would have done in the old days. Next, and very critical to the question, are two very important aspects covered in some detail by Ishmael concerning one, proportionality, and two, collaboration. In terms of discovery in the UK, or disclosure as they call it, which is another story and we certainly don't have time for, proportionality is the overriding objective in discovery. And lawyers in South Africa may be very surprised to hear that, but it is. Proportionality is the overriding objective. And I'm delighted to say that principle commenced and is well established now in the UK, my home country, has spread through America, and proportionality is now big, big topic, a big feature of litigation life in other parts of the world. But essentially, proportionality means that if your case is worth 1 million rand, then you cannot spend 5 million rand on discovery. Well, of course, the truth is you can, but you won't recover it if you're successful. So given that using technology will reduce the costs, which I'll mention in a little more detail later, Mel, I promise, you can see the importance of proportionality, especially when coupled with collaboration. Now, to some lawyers, the notion of collaborating with the other side is an anathema. Well, I'm sorry to say that is old-fashioned and simply not conducive to the proper and smooth running of a case, as well as the important effect of reducing the costs. eDiscovery technology lends itself to collaboration in many, many ways, which are too long and complex to mention here at this webinar, but it is yet another important feature of cost reduction, and all of these are referred to in the book. And so finally, a quick look at the problem of costs that Mel asked me about. Here, lawyers, is the real problem. Global statistics tell us that at least 70% of the total cost of a case is the lawyer's review of documents. And it is that 70% that eDiscovery attacks by using the technology. The lawyers will personally review less documents. Now, some lawyers, and I had this in the UK and I've had it here in South Africa, some lawyers say, oh, hang on a sec. So you want me to have technology, which means that I won't do as many hours as I normally do, and therefore I won't earn as much money. Thank you very much. Goodbye. I'm not interested. Well, again, with the greatest of respect, that is a short-sighted view. The truth, of course, is if you spend less hours on one particular case that you've won by offering to use technology for your client, you'll have more time to be able to do other cases as well. Whereas if you just have the one case and you don't have technology and you do all of that stuff and you bill, you'll probably never see that client again when that client understands that you could have saved him an awful lot of money. So that, again, with respect, is an objection I'm not really interested in. The truth is 70% of the total cost is lawyers' review, and we need to deal with that. So that is how Discovery reduces costs, Mel, which I think answers the second part of your question.
Thank you so much, Terry. And just before we go into, we've got one or two more questions I wanted to explore with you. And Terry, it's one of, you said, if you can understand your data, you will understand your case. I find that to be such a profound quote, even in the corporate world and in LexisNexis. We use that all the time. And our CEO always asks us about what does the data say? So where data is a new currency and almost everything has advanced to digital platforms, can you take us through the advantages of processing data using eDiscovery technology? And further to this, make it practical. Can you share some of the eDiscovery software that is available in South Africa and Africa? Thank you.
Thank you, Mel. Interesting, and Judge Kollapen mentioned exactly the same phrase. It is a phrase that I use very often: know your data, know your case, or understand your data, understand your case. You have to know what data or documents you have before you can begin to understand your case. And you know, interestingly, I often use this phrase when I'm faced with one of the most common objections to using eDiscovery technology. And that objection is, what is the point in going to the expense of technology when most cases settle anyway? Well, my answer to that is that if you settle, you must do so from a position of strength and not weakness. Otherwise, you are failing your client. And you can only be in a position of strength if you know the data and documents in your case, which will help you to advise your client on settlement or otherwise, and if settlement, then quantum. Now, this concept, if you like, is very important in South Africa when you consider Rule 41A, which makes it mandatory to consider settlement or mediation. So I repeat the point, know your data, know your case. Whether it's going to settle or go to trial is completely irrelevant. Now you asked me about technology and advantages. Again, this is one of those which is a 2-minute answer or a 4-hour answer. Well, as I mentioned earlier, I think it was the previous question, one of the first areas of eDiscovery technology that we use when a case arrives is early case assessment. Now, going back to my comment that, let's say there could be 500,000 documents or more, can you imagine how valuable it would be if within just a few days of obtaining your data, for example, you could learn exactly how much data you've got, how many documents, what kind of documents. And by that I mean, all right, there's 500,000 documents. Guess what? 300,000 of them are emails, 100,000 are spreadsheets, etc. So a breakdown of the types of documents is available quickly. A date range. Significance of that is that it would tell you the earliest document is, for example, dated 2015. The latest document is dated 2020, but there is a huge spike of documents between 2018 and 2019. That starts to tell you, I need to look at 2018 and 2019, because that's clearly when most of the action in surrounding this case occurred. Then, supposing you had the value of knowing how many people were involved in the data that you had collected. We call them custodians in the eDiscovery world because they are the custodians of their data, if you like. So to know how many custodians there are within the collection of data that you've got quickly is enormously valuable. And supposing we went even further and said, and by the way, custodian A emailed custodian B more times than anything else that happened in this collection. That would then start to tell you about the fact that custodian A and B are major players, and will help you again to strategize and work out your review strategy, how big a team you require, what kind of specialist skills, if any, are needed. So that is almost the first thing that eDiscovery technology can do, but it tells you something so quickly about your case. Thereafter, working with your service provider, and I should tell you that I've written an entire chapter in the book about choosing a service provider. But anyway, working with your service provider, there is a wide array of technology features available in eDiscovery solutions, all of which are aimed at reducing the volume of the documents, whilst at the same time increasing the relevance of the remaining documents. It's impossible to discuss all the features here for obvious reasons, but with the advice of your provider and perhaps a consultant like me, here's just a snapshot of a few. We've got features such as keyword searching, which will find within the big collection of 500,000 documents only those documents which contain a selected particular keywords or phrases. We have clustering, which groups together similar documents for ease and speed of review. We have near duplication, which finds documents that are almost duplicates. for a quick determination on elimination or otherwise. We have email threading, which shows the strings of email exactly where they exist, rather than looking at each one singly. We have concept searching, which shows documents containing certain words or phrases, but only where those words or phrases refer to a specific concept. And of course, we have the very important technology-assisted review, or TAR, as we call it. This is probably the most important, at the moment anyway, most important feature of eDiscovery technology, because, and I say that because there are decided cases now all over the world in which technology-assisted review has not only been used, but has sometimes been even ordered by the court to be used. It's a long and complex subject, and one I've devoted a great deal of time to in the book. But in the simplest of terms, TAR is using AI, artificial intelligence, to find documents of the same thought processes as the reviewer's previous decisions. Now, there are other features, and of course, it's about using the right ones for each case. And as I say, you need skilled and experienced advice on this. But because all the data has been processed within the technology, capturing the all-important metadata that I mentioned, and also capturing the text for ease of searching, the technology can do all of the work that I have just mentioned with help and support from skilled and experienced service providers. Mel, you asked me about software solutions. I'm always reluctant to refer to certain solutions or providers in arenas such as this, as people will say, well, you didn't mention this or you didn't mention that. And we're getting to discussions about whether some solutions are actually eDiscovery or not, or whether some have other features that others don't. So I'm not chickening out, but I'm not going to name any names. What I am going to say is, suffice it to say, that we do have some options in South Africa right now, including the global market leader. And so if anyone really wants to know about solutions or providers, I would suggest it's probably best to contact me outside of the webinar.
Thank you, Terry. And for the interest of time, I'm going to leave the one question I had for last. We've got a few questions that's come from our attendees, and James Musey asked this question right at the start, Terry, and he would like the answer from you. How do you get the legal system in a country to create civil procedure rules that deal with electronic documents? It is not directed to us, he said not specific, but then he was very specific. He wants you or judge to answer it.
Okay, well, the answer is that you lobby the right people. I went through this in the UK, and what you have to bear in mind is that the rules of civil procedure in many jurisdictions that do contain, do have eDiscovery incorporated, we're all in the same position that South Africa was at some stage, but they've all achieved it. And that is because groups of people or individuals have got together and have lobbied the correct departments of justice or whatever it might be, and made the case for eDiscovery. This is exactly what happened everywhere that I know. It started out in America, obviously, happened in the UK, and I was partly involved in that. It's happened in New Zealand and in Australia and in Ireland and various other jurisdictions. As far as South Africa is concerned, we've got quite a long way, but everything in South Africa takes a long time. For an Englishman like me, I've had to learn a lot of patience in this country. It's not easy for me. But the simple answer to the question as far as South Africa is concerned is that I found the right people. It was the people at the rules board. I went to see them. I made a presentation. They invited me to present to a particular committee, which I duly did. I sought the support and sponsorship of the Law Society of South Africa, who joined in and helped to draft proposals to change the rules. And as a result of all of that, as Judge Kollapen mentioned, the Rules Board have appointed a task team to consider all matters electronic. They've published their first thing right now, which we like, but it's not eDiscovery, by the way. So they're still working on that, we assume, and we are sure that they are. So that's, I hope, an answer to the James's question.
Thank you. Thank you, Terry. For the other questions, we will get Terry and Ishmael to answer it for us, and we'll email it through to our attendees. But I do have 2 minutes left. I would like Sam to tell us why people should buy eDiscovery.
Yes, thanks, Mel. Very simply, I just want to say that if you don't want to be left behind, if you want to improve the productivity, the efficiency of your firm, you need to get a hold of this little book. South Africa still has a long way to go in terms of embracing technology, but this book is the perfect place to start.
Thank you. Terry, and a quick one from you.
Okay. This is about why the book is important. I see this book as a catalyst for a paradigm shift in how attorneys, advocates, even judges think and work in South Africa. I see general counsel and legal teams using the book to learn how to measure and control their eDiscovery costs. I see law students learning about technology and eDiscovery before they qualify and therefore get thrown in at the deep end. I see the book supporting the views of the Law Reform Commission about reducing litigation costs, and I hope the book will help gather further momentum towards a rules change with the Rules Board. But my final comment, Mel, is I see the book helping everyone to realize that you should not wait for the rules to change, because eDiscovery is right here, right now, alive and kicking.
Thank you. Thank you, Fedesha. I want you to put on your camera so that I can say thank you to Terry and to Sam and to V and to everybody that supported us. And please rush out and get the book. I certainly believe that, as Terry and Sam has told us, and V has introduced the book to us, it is a transformational book. And it certainly is for everyone, corporate, the legal professionals, the students, the lecturers out there. Please go and get the book. And please join us for the next webinar. We're going to have another one where the panelists are present, and it's going to be a lot of interaction as well. Please go to www.lexisnexis.co.za and join us for the next one. Thank you, everybody, and goodbye.